sa nga niya karon ani nga virtual room. Salamat sa paghimo ni Attorney Jessica Jimenez na instrumento sa imuhang grasya sa kaalam. Kami madasigon sa kanunay sa pagpaminaw sa iyahang mga lecture para makabot unta sa mga mutake o bar ang ilahang gipangandoy nga kalampusan. Sa kanunay Ginoo kami mga kanimo sa nagpamasa salamaton nga imo kaming gilamdagan ug gahayag aron ang among panghunahuna dunay kahapsay o labi na sa kapiskay sa maintang lawas. Salamat kanunay Ginoo sa paggiya kanamo sa among maayong desisyon para sa among pamilya, kabanay ug ingon man sa among pagpanarbaho. Kini among gipangayo pinaagi ni Kristo among Ginoo, inubanan sa iyang inahan nga si Birhen Maria. Amen. Sa ngalan samahan sa anak ug sa Espiritu.
Daghan
Good
kayo.
evening, Doctor. Good evening. Good evening, Attorney.
Good evening, Attorney.
Good evening, Attorney Amistad, Attorney Umpad, Attorney Panilagaw, Attorney Estorjo. Tonight, we will have a very exciting topic about honesty is such a lonely word. Honesty is such a lonely word. I have invited some of my friends who are in HR, who are managing companies, because there are so many cases of dishonesty happening in the company. And tonight I will discuss so many cases decided by the Supreme Court involving stealing of company property, malversation of company funds, falsification of company documents, breach of trust, conflict of interest, bribery, and other forms of betrayal of trust. We should always remember, ladies and gentlemen, that the relationship between an employer and an employee is based on trust. And when that trust is violated or betrayed, it is very difficult for two people to live together if they do not trust each other. In fact, in marriage, sometimes I understand based on my analysis and research that two people living together might have or might be losing affection for each other, but as long as trust and respect, two elements, trust and respect. That's why in the labor code, a violation of the trust, a violation of the trust would constitute fraud or breach of trust by the employee. And a violation of respect makes an employee commit serious misconduct. So the last two meetings, first we discussed serious misconduct, then we discussed insubordination. Tonight, our topic is fraud. Next meeting, our topic will be gross and habitual neglect of duty. So, everything that we are going to discuss tonight is pertaining to honesty and dishonesty. So I have made a research of cases involving salesmen, cashiers, even faculty members, Dr. Velasco. There is one case where the university terminated the services of a faculty for plagiarism, presenting modules and materials that he claimed to be authored by himself or herself, and yet it was discovered that it was a violation of copyright owned by another person. So For those who are not taking the bar but are here to know for purposes of HR, we will discover a lot of acts and omissions attributable to our employee that may cause the rupture of relationship because of loss of trust. So when you take the bar, you should always be remembering, and also for you who are here for HR, before you make a decision, you must be aware of the formula. How can you be sure that your decision to terminate an employment will be sustained by the NLRC, by the labor arbiter? The first thing is you must have evidence that he committed an act constituting a just cause. Never mind the authorized cause, because authorized cause pertains to financial reasons, and those are retrenchment, redundancy, labor-saving device. We will have a separate session for that. But tonight, we will just concentrate on one just cause, and that is fraud with LOTAC, LOTAC, loss of trust and confidence. If you can prove the just cause, then the due process, that is the quality control of your decision. You will have a correct decision, legal decision. You can defend your decision before any tribunal, before any court, because you adhere to the requirement of the law. So you must always remember the provision of Article 297, which is now Article 282. So one of the most important provision there, aside from serious misconduct and insubordination, is fraud. And the Department of Labor issued Department Order 147-15. This is the amendment to the rules and regulations implementing the labor code, particularly Book 6, because tonight we are discussing Book 6 of the labor code. And these are the elements of fraud. First, you have to have evidence that the employee is guilty of an act or an omission. Sometimes you commit dishonesty by omission because you have knowledge of something that you withhold from management. You have knowledge that, for instance, that your subordinate is committing malversation of company fund. You are the direct superior. You close your eyes. So that is an omission that may cause the top management to lose confidence in you. So here in fraud, there must really be an act, like the act of that nurse in St. Luke's Medical Center, if you remember that, I discussed that once, who tried to take away some materials and supplies like sirens, like simple supplies, but considering the importance of being honest, you are entrusted with company property, with an hospital property, and then you take it away without permission of the duly constituted authority of the company. So that was an act, the act of bringing away, although it was not consummated because of the guard. There was really an overt act already. That in criminal law, the elements of theft, there was already the act of carrying away. And there was no permission from the owner. and there was an intent to gain. And then the act or the omission involves a breach of legal duty. It is your legal duty to protect the asset, the property, and the money of your employer, and you violate that duty by attempting to appropriate for your own use or attempting to gain or to possess a property that belongs to your employer. And it must be committed against the employer or his representative. So even if the employer, even, we have decided cases by the Supreme Court stealing company property even if it is not owned by the company. And that was an employee in the bottling line who committed theft, and the subject matter of theft was the who stole his cell phone was a particular co-employee. He reported that to HR, and HR made an investigation, and that there were witnesses, and so he was found guilty. Now, just like any Filipino, the one who complained said that naawa na lang siya, no? He does not want the employee to be dismissed just because of a cell phone that is very cheap. The old type of cell phone that was just even less than 1,000 pesos. And so he executed an affidavit that he has already forgiven the employee. But management was not bound by that. Management said that even if the property does not belong to the company, if it happens inside company premises, and regardless of the fact that the owner has already forgiven the offender, that is between them. Insofar as the company is concerned, there was a violation of trust, and the company could not tolerate the act of stealing within its premises. And the Supreme Court upheld the decision of the company in terminating the services of the employee. And long years in service is not a defense, even if it is the first offense.
USEC? USEC, naka-mute ka.
USEC, yeah. You're muted, attorney.
O kanina pa?
Good evening, attorney. Just now, attorney.
Okay. Good afternoon, Ma'am Grace. Okay. As I was saying, even if the owner of the property has forgiven the offender, if the act of stealing is done within company premises, and even if they have settled the problem between themselves, the settlement is only pertaining to the civil liability. But insofar as the administrative offense is concerned, it is an offense against the company. And the Supreme Court has been very consistent in upholding the validity of the dismissal of an employee when it comes to stealing. Long years in service is not mitigating, no? And you can only, long years in service can be invoked only as mitigating when the offense is negligence. But when the offense is serious misconduct, if you remember the case of Visayan Electric Company, the union president was dismissed because he publicized derogatory remark against the Abuitis family and against the company. Even if his issues would be valid, but publication is not the proper forum because there are internal mechanisms to air grievances, to seek redress within the framework of the collective bargaining. Considering that he was the union president, he should have availed of the grievance machinery to ventilate whatever complaints he had against the company. And so the Supreme Court also did not give due credit to long years in service, and he was the union president. So this is a very serious matter, ladies and gentlemen, and when it comes to dishonesty, the Supreme Court is unforgiving, no? Magbigay pa ang Supreme Court kung it's just absenteeism, no? Doon ako nagtataka din, no? And maybe that is the culture of the Filipino, that our courts, even the Supreme Court, seems to be tolerant when the offense is absenteeism. But when the offense is stealing, just like what happened in Apo Cement in Naga, one manager was dismissed because there was a testimony of the supplier that this manager was asking money, kickback, for his signature concerning a big machine that was purchased by Cemex, which is the owner of the company now, no? And by the mere testimony of the supplier, management decided to dismiss that manager, senior manager, and he filed the case until the Supreme Court. The Supreme Court upheld the decision of management. So here, I will share with you this case, which is very new, 2020 case. You know, I really prepare every time I appear before you because I have to research, no? You know, to be a professor, it's easy to learn. What is more tiring and exacting to your health is the research and the preparation of the materials, because I have to do the PowerPoint myself at my age. But anyway, this is a labor of love, no? So every Monday, those who are invited now, you can come back every Monday. This is a free seminar that I give to the College of Law of my alma mater. And since this involves, that's why I'm inviting you, no? Okay, so this case is about a Filipino who was hired by an international shipping organization, company, through a Manning. And you know that in the whole world today, there are 300,000 Filipino marine officers and seafarers in all the 7 continents and the 7 oceans all over the world. There are Filipinos. Also, one Filipino by this name was involved in an alleged syndicate. You know, the vessel was transporting oil from the Middle East, bring them to the Philippines. For Petron, it is you bring the oil to Bataan. And other oil products. For Shell, it is in Batangas. So this guy was found to be involved in a syndicate. Can you hear me?
Yes,
Yes,
USEC.
Yes, USEC.
The connection is unstable, but we are, pagka nag-pray tayo, isama natin yung Wi-Fi connection. Okay? So, somebody sabi, the Supreme Court here stated that theft of company property is the highest form of ingratitude. This is the word of the Supreme Court. Stealing the property of your employer is the highest form of ingratitude because this guy was employed by the company for 24 years and he wasted his 24 years. All the retirement benefits are forfeited. He does not receive any separation pay or back wages because long years does not mitigate the penalty for stealing. And in fact, this guy was guilty of 2 offenses in the past, 2003 and 2013. So this is not his first offense. And there is a pattern. So really, the Supreme Court, speaking through Madam Justice Perlas Bernabe, Estela Perlas Bernabe, the chair of the last bar exam, did not find it difficult to uphold the decision of management. So we will go to another case. This is the case of Del Monte in Davao. You know, Del Monte, no? Mga wrong spelling minsan yung ating kuan, huwag na ninyong tingnan yung mga minsan nagkakamali sa pagmamadali. Del Monte Fresh Products. Ito si Mr. Reynaldo Betonio was employed by Del Monte. Ang trabaho niya is port operations. You know, Del Monte is not only engaged in pineapple, but they are also doing banana, papaya, and other fruits. So this manager, port operations manager, and this is a very highly paid position. He was based in Panabo, Davao del Sur, where the wharf, that is where the big vessel, the giant vessel would dock so that all the products of Tadeco, which is, you know, that is owned by Florendo, and this Del Monte and also Dole and many other agricultural products. They are all transported to Japan, China, Taiwan, and all other countries. No? And, you know, this case is very unique. You know why? Because this person is not dishonest, but he was very careless. Sa dami-dami niyang palpak sa kanyang mga desisyon at sa kanyang mga diskarte, nagkakamali-mali. For instance, imbes na ipadala yung products sa Japan, ipapadala niya sa Malaysia. Imbes na yung a certain kind of banana should be sent to Yokohama or Tokyo, he sent another form another kind of banana or another product. And then there are many products that are wasted because of wrong scheduling, no? And therefore, in other words, when he was audited by a panel of auditors, it was found out that the proximate causes of all the blunders and the mistake was his failure to make correct decisions. And he was in charge of the warehouse, meaning all those in the warehouse, he is in charge, and there are many products that are not accounted for. And the transporting this product from the warehouse and to load it into the vessel, that is his responsibility. And so, in other words, to make the story short, the Supreme Court, I think one of the first time where court nothing to do with honesty, because this person has never been charged of dishonesty. He is just being charged of carelessness, which caused so much damage, tremendous losses, millions to the company. And yet the Supreme Court awarded separation pay because he was not dishonest. He was only negligent. You see, our culture is we are somehow tolerant of negligence, but we cannot tolerate dishonesty. And the Supreme Court said, okay, he should be dismissed. He does not deserve reinstatement. But because of his years of service to the company, he should be paid. No. If I were a member of the Supreme Court, I would write a dissenting opinion that if you say that there is just cause, so why give him separation pay? No. But anyway, I also remember another case where an HR vice president for HR of a global company based in Clark, based in Clark. And this company has operation in South America, in Asia, and in Europe. No? You know, these branded long sleeve shirts carrying global brands. Many of them are manufactured. And this company is the one doing this. And this vice president for HR was dismissed for loss of trust and confidence. She was not dishonest. But the other managers have complained to the president of the company that all the advice of this HR manager, can you imagine your lack of knowledge of the labor code, of labor laws, and you claim to give advice to other senior managers of the company, and also to wrong decision, which redound to damage on the part of the company, not only physically, but the reputation of the company. And so, today, somehow that the concept of loss of trust and confidence is no longer just limited to honesty. It's not just about crime against property, or it is not just about handling of funds or handling of materials, resources, but also incompetence. You know, I remember there was a case about a driver. You, Cebuano, tayong mga Cebuano, we are aware of there is a transport company that is called Fress. Alam mo ba yan, Ma'am Velasco, yung Fress? yung series. Ang niyan multi-billionaire based in Bacolod, family. Tapos yung matriarch, yung inayan when she was still very young, no? She called a driver, merong driver na personal niyang kilala na had been with the company for 30 years. I said, ikaw, Kulas, si Nicolas, there are series of reports that you have been involved in many traffic. Kulas, because of your eyesight, you have a failing eyesight. Wala na akong tiwala sa iyo mag-drive kasi bayad na lang tayo ng bayad. Nakasagasa ka ng baboy, manok, kung ano. Buti nga, hindi ka pa nakasagasa ng tao. Kung ano-anong nasasagasaan mo. So wala na akong tiwala sa iyo. Ito namang clerk na literal yung translation doon sa word na wala na akong tiwala. Nakalagay doon, termination of employment for loss of trust. And that the Supreme Court declared that dismissal illegal. Because according to the Supreme Court, the original meaning of loss of trust, it should be related to handling of property or company fund, not about competence. Competence may be related to gross and habitual negligence. Or if you wish to terminate an employee whose eyesight has been failing, there is a provision in the labor code about medical separation. When the nature of his disease is such that his continued presence may pose a danger to himself or to his fellow employees, you do not dismiss that person, you separate him. Dismissal is different from separation because separation, but dismissal is based on just cause. So, in other words, therefore, that dismissal was considered illegal. Now, going back to our topic here, in there was a guy by the name of Roberto Quis, was decided by the court only last February 2020, before the COVID crisis. And this person was a senior technician. He was very senior already because he had more than 30 years of tenure in Philippine Airlines. Alam niyo, yung Philippine Airlines before, lahat ng mga maintenance engineer were employee of PAL. Pero nung nagkahirap-hirap na ang PAL, they are outsourcing already this activity of maintenance of the aircraft. The one in charge of maintenance is no longer PAL employees, but they have a company by the name of Lufthansa, which is a joint venture with the original Lufthansa in, I think this is a German company. And they are highly recognized worldwide as expert in maintenance of aircraft. And so yung si Mr. Quizon, nag-retire sa PAL, nakuha yung retirement niya, and then he was hired by Lufthansa. And then he was there for more than 10 years already. And what happened on March 10, 2005, there was an accidental lighting. You know, when an aircraft, there are lights in the aircraft that should not be on except when there is an accident. And so that was blamed on him. That why did that aircraft that flight, which is not supposed to be owned because there was no accident, and it caused panic among the passengers. That was blamed on Mr. Quison Craft on April 15 without following the safety protocols. But you know, the operation of an aircraft is a joint among teams, not an individual responsibility. So, sa madalit sabi, this person was dismissed by Lufthansa because of loss of negligence na naman, no? Which is based on loss of confidence based on gross negligence. He filed a case sa labor arbiter. He lost the case. He filed a case, an appeal to the NLRC. He lost the appeal. But he filed a petition with the Court of Appeals, which is also based in Cebu. By the way, the presiding justice is Gabi English, no? Former Dean of the College of Law of San Carlos, a very competent and very honest justice, Attorney Gabi English, who used to write in the Sun Star. And you know what happened? The Court of Appeals reversed the decision of the NLRC and decided that Mr. Quison was illegally dismissed because there was no proof, there was no evidence that this negligence could be attributed to him. It's very easy to blame people. It's very easy to charge an employee, but how to link, no? Because I have shown you the elements, you have to prove all the elements, and by substantial evidence, you have to establish that the person you are dismissing should be guilty of these acts, not a group of people or not a team, but he himself, no, alone. If you are dismissing him alone. So, you know what happened here? This Mr. Quison, I think, was receiving pesos. And can you imagine the back wages for 5 years? From 2005, when he was dismissed, to 2020, February, assuming 5 years multiplied by 12 months, that is 5 times 12. Oh, magkano yan? No? And you multiply that by 100,000 pesos. That is only the back wages. About the separation pay. The separation pay is 1 month for every year of service. Or the retirement pay, whichever is higher. No? So this person ended with a lot of money because of the illegal dismissal. The Supreme Court declared that he was illegally dismissed. And this was written by a new justice of the Supreme Court, very young. I think this is younger than Marvick Leonen, now the youngest justice in the Supreme Court from La Union. No? So it is not true that President Duterte is appointing only people from Mindanao. He has appointed a lot of Ilocanos. No? And he has also appointed justices from Ateneo, not just from San Beda. Okay, we will now go to Coca-Cola. This person by the name of Fernando Vega was hired as a salesman by Coca-Cola in 1976. But, you know, because falsifying the sales report in order to make it appear that the sales is lower than what was actually sold, and then there could be they could not reconcile the stocks in the warehouse versus the sales. So there was an audit. He was found guilty, and this guy filed a case. You know, you are from that place, and the labor arbiter took pity in you. So usually the labor arbiter decides in favor of labor, except lang yung kay Quezon. No? And he won. He won before labor arbiter and before the NLRC. And of law, before the decision of the NLRC was appealable directly to the Supreme Court, because the Court of Appeals was not involved in labor cases before until the case of St. Martin funeral. And so this case happened before St. Martin funeral. So from the NLRC to the Supreme Court, and the Supreme Court, through Justice Hugo Gutierrez Jr., decided in favor of management that this guy deserves to be dismissed because he was dishonest. No, I think the Supreme Court is very consistent when it comes to dishonesty. The Supreme Court is very unforgiving to the employee when it comes to dishonesty. So with all these things that I wrote here, I just want to highlight that the Supreme Court said a high degree of confidence is reposed on the salesmen. The salesmen are confidential employees because they are handling cash. At those time, Coca-Cola and San Miguel, hindi pa bago yung method of selling noon. The salesman himself handles the cash. So pag nasa probinsya, maraming walang checking account, they pay in cash. So isang araw lang, they have in their possession 200,000, and then they have to remit that immediately to the cashier who is waiting in the warehouse. So if you do not remit that, that is already a ground for charging you. And when I was in San Miguel for 12 years, I investigated and caused the dismissal of, I think, more than 100 salesmen. That was my job, to have the final decision as to terminate to approve the termination of salesmen all over the Philippines. No, because San Miguel was very centralized in decision making at that time when I was there for 12 years, since 1986, immediately after the EDSA revolution. So what you will remember here is when it comes to salesmen and when it comes to malversation of company fund, when it comes to alteration of documents, the Supreme Court is unforgiving. Those are clear acts that would justify termination of employment for loss of trust and confidence. So another case is the case of San Miguel in Bacolod. In Bacolod, there were 3 salesmen who were audited and found that they were guilty of underreporting their sales. Again, this is the same pattern. That's why I will not burden you with the details. I will just go directly to the conclusion of this case. If you become a lawyer in the future and your client is being charged with complete documentary evidence, my advice to you is just to ask your client to humble himself, ask for forgiveness, and negotiate for separation pay. Because if he fights it out, maybe he will win before the arbiter or the NLRC. But in the Supreme Court is very, very strict when it comes to dishonesty, especially salesmen. No? On appeal, the Supreme Court decided in favor of management. The court noted that the company had enough reason to lose its trust, no? Because salesmen are involved in high degree of trust and confidence. So this is quite different. This is in Tugigaraw, Cagayan, and in the Cagayan Valley region, including Isabela and Nueva Vizcaya. Itong salesman naman ng San Miguel, ang ninanakawan nila yung kanilang customer. Meron silang favorite na malaking dealer ng San Miguel products in Tugigaraw. Matanda na ang may-ari. So pag dumating yung mga salesmen, pinababayaan na lang ng matanda. Pumunta kayo sa bodega sa likod, kunin ninyo yung mga empties. Tapos i-deliver ninyo yung bago kong binili, mga 100 cases of beer. Kasi malakas inumin eh. Mga Ilocano, malakas uminom para ding mga Bisaya eh. So, okay. Ito namang mga salesmen, meron pang mga produkto na milaman pa sa likod, claiming that it was an empty nila. Ninanakaw nila yung produkto na binili na ng may-ari, tapos ibabalik nila doon sa truck, tapos iikot lang nila, yun naman mismo ang i-deliver din nila. No? So, they are stealing from the customer. And that has become a pattern already. Nagkahalata na yung matanda eh. Kasi laging hindi mabalanse yung kanyang inventaryo. So because of that, pinabantayan sila until na nahuli sila. And this owner filed a written complaint, formal letter of complaint. And they were dismissed. Justice Vicente Abad Santos. No? Do you know that Justice Vicente Abad Santos was the son of Chief Justice Jose Abad Santos? And he was captured by the Japanese in Karkar City in 1941. And he was brought to Lanao and he was executed by firing squad. And that Jose Abad Santos is from Pampanga, but he was sent by Don Sergio Osmeña, no, who was the vice president of Manuel Quezon, to a certain mission here in Cebu. And he was arrested, he was captured by the Japanese, and he was executed. And this, the son is Vicente Abad Santos, also became a justice, but not a chief justice like his father. So I'm just binibigyan ko lang kayo ng mga ganung mga story para ma-inspire kayo. Another case of San Miguel, magsawa kayo nito mga salesman, ay bibilisan ko lang ito. Basta ito, ang conclusion dito is still wala pang nananalo na salesman sa San Miguel at Coca-Cola basta ang kaso ay malversation at falsification. And the Supreme Court here, speaking through Justice Panganiban, who became a Chief Justice to take the place of Chief Justice Artemio Panganiban, no? And this is in quoting verbatim the statement of Justice Isagani Cruz in the case of PLDT versus NLRC. Do you know that case? That is a very important case, no? Because it is there where the Supreme Court that said that if you steal from your employer and then you are caught and you are dismissed, You cannot come to court and say, pity me because I'm poor. Even if you are poor, you are not deserving of compassion because what you have done is the greatest act of betrayal against your employer. So ang kaso kasi doon sa PLDT, which is relevant to our discussion tonight, is about bribery. Kasi nung araw, Dr. Velasco, when you were not yet born, and Ma'am Grace, hindi pa kayo isinilang sa mundo. Nung araw, wala pang cellphone. Wala pang cellphone. No? And para lang makabitan ka ng telepono, itong dalawang matrona, alam mo naman, pag mayaman ka, ang tawag sa'yo matrona. Pero pag wala kang pera, ang tawag sa'yo si tanda. So, matrona, mayaman to eh. Pumunta sa PLD. No? Ang nakausap nila doon, yung si Marilyn Abukay. Sabi ni Marilyn Abukay, alam mo naman ma'am, merong kalakaran talaga yan ma'am na kailangan magbigay kayo ng for the boys para malagyan kayo ng, kasi ang bayo ng lugar ninyo ma'am, magtatayo pa yan. Wala ang cellphone noon, ilan-line lahat eh. Nakapila ka. Can you imagine? Saan ka makakita ng makabitan sila. So, sa Marilit sabi, itong dalawang matrona na ito, nagbigay ng pera, tag 15,000. Malaki na yan nung araw, 15,000, para lang makabitan ng telepono. So, ito, naghintay sila. Ang tagal-tagal nilang naghintay, hindi pa rin sila nakabitan, pabalik-balik sila. Tapos na parang nagdududa na sila kay Marilyn Abukay. So hanggang dahil hindi na sila nakabitan, nagreklamo sila, nag-file sila ng case. Si Ma'am Val Bernabe is and I will. And Marilyn Abukay during the investigation was very honest by saying, you know, I admit that I accepted that. But yun na ang kultura dito. Everybody is doing it. Why single me out? No? So I have been in the company for more than 20 years. So if you want to terminate my services, just give me retirement and I will go. I will return the money of itong matrona. But you know, the LDT decided to terminate her services without giving her retirement benefits. She filed the case. And she won before the NLRC on the ground that first offense daw niya, 20 years, you know, the hands of the best writers of decisions used to be the dean of the College of Law University, and he was really most decision memorized until now. And so Justice Isagani Cross said that, sinabi niya doon sa desisyon niya, you come here before the court asking for compassion, you are invoking social justice. No, sabi niya, social justice should not be made the refuge of scoundrels. Compassion is an imperative of every humane society, but only when the recipient is not a rascal claiming an undeserved privilege. Can you imagine? Rascal. Dito sa Pilipinas, tanggap ka ng 15,000, rascal ka. Pero pag congressman ka, magnakaw ka ng 15 million, anong tawag sa'yo? Honorable. Pero pagka si Marilyn Abukay ka, Sa bagay, kahit ano, magnakaw ka ng milyon, magnakaw ka ng pariho rin yan pag nanakaw. So deserving talaga. Iyan ang ngayon ang nagiging landmark decision. And when you take the bar, and you, in HR, if you make a decision, regardless of the amount, regardless of the length of service, when it comes to dishonesty, very clearly, the Supreme Court will uphold your decision to terminate. Ito naman, Pepsi Cola. Alam niyo ito, itong taong ito, he was assigned in Urdaneta, Pangasinan. I'll just tell you the story para madali. And alam mo, Pepsi Cola was competing with Coca-Cola. No? I worked for San Miguel for 15 years. So, sakop din namin ang Coca-Cola for 15 years. But I worked for Pepsi Cola for 5 years, no? Later on. So, itong tao na ito was assigned as a sales manager in Pangasinan, Urdaneta based. Because if you are a manager, you will be given a territory. And nobody can enter your territory. All the sales of Pepsi Cola will be under you in that territory. So itong mga sales manager were summoned by management sa planta ng Pepsi Cola sa Tunasan, Muntinlupa. Yan ang head office na ko. So this happened before I joined Pepsi Cola. So this guy, together with all the sales manager in the whole Philippines, were summoned to a meeting. The company president decided that starting Monday, today is Friday, starting Monday, we will increase the price for every bottle of Pepsi Cola by a certain amount. Okay, so pagkatapos ng meeting, uwi na siya sa Pangasinan. Alam mo ang ginawa niya? Binili niya lahat ng supply ng Pepsi under the old price. Kasi ang effectivity ng pag-increase Monday pa. So he was using an inside information to aggrandize himself. Kasi sabi niya, bilhin natin lahat. Yung sa pamilya niya, binili niya lahat ng available na Pepsi sa buong Pangasinan. Tapos pagka Monday, pinagbili niya sa higher price. And he was found and he was investigated and found guilty. You know, what is the decision of the Supreme Court here? The Supreme Court said that since he was retirable, he should be considered suspended for 1 year. That's why I'm telling you, suspension of employee is not limited to 30 days. Suspension of employees can go to as far as 1 year. In fact, in another case involving a flight stewardess of Philippine Airlines, Monte versus Philippine Airlines. Flight stewardess was apprehended by PAL and charged of pilferage of yung mga chocolate ba? Chocolate sa plane. Inuuwi na. Mga ganong mga bagay lang. Tapos na-terminate yung flight stewardess. And then she was suspended for 1 year. Of course, si Justice Marvic Leonen, you know, he will be the chairman of the bar. Pina-reinstate ni Marvic Leonen. And he even awarded moral damages because it was not proven that the flight stewardess was really guilty of that offense, or suspension for 1 year was too harsh a penalty. But anyway, that is a rare case because in many other cases, the majority is that regardless of the amount, regardless of the length of service, if it is dishonesty, so when you take the bar and you are confronted with that question, and the issue is whether termination or suspension is enough, You just state that as a general rule, the long line of decision says that this should be termination, regardless of length of service, regardless of amount. However, no, in very few cases, the Supreme Court sometimes takes pity at some employee, especially if she was or he was remorseful, he was very humble during the investigation, he was very cooperative, he was not antagonistic, he was not adversarial. On the contrary, he was very remorseful and very regretful and very apologetic. So sometimes, because of that, the court would take pity. But in the light of the decision of PLDT versus NLRC, that compassion for the poor is an imperative of every humane society only when the recipient is not a rascal claiming an undeserved privilege. We can no longer apply compassion when it comes to dishonesty, especially bribery. So this sales manager was dismissed and the dismissal was found legal. Now, another case, Coca-Cola, senior financial accountant, reimbursement of meals. Alam mo ito, mga simple lang ito KFC lang, McDonald's is even less than 300 pesos. But this is falsification, altering of receipts. The amount was changed. And this is unforgivable. There was a precedent in the case of Baguio Country Club. There was a woman who was the HR manager, and she purchased a cake in Red Ribbon along the Session Road, and the amount of 175 pesos, that was already big cake at that time, was changed into 475. And even if her defense is that I was not the one who falsified that, it might be my staff or whatever, but it was not me. But the moment you are the one who signed the liquidation report, you are the one who is the recipient of the reimbursement, then that makes you guilty. And that guilt is punishable by termination of employment, regardless of the number of years of service and regardless of the amount, because that is dishonesty. Can you imagine? So if you want to have this book, those are available. Ito yung financial, yung magkano lang, binili niya sa McDonald's, 111, Shakey's, 174. Tapos na-altered yung mga receipt. No? Na-altered ang mga receipt. And the official receipt, of course, has a duplicate. It's very easy to check and to confirm. So, sometimes, kung ako ang management yan, tatanggalin natin to, hindi dahil lang sa dishonesty. Tanggalin natin to sa katangahan niya. Kung senior financial accountant siya, excuse me, but why did she go to that extent? No? What kind of responsible official? This is Coca-Cola export. This person must be receiving a high salary because this is an international company. That is not the local Coca-Cola company. It's the New York-based Coca-Cola export. This is the one that is selling the formula, the syrup. Kasi ang Coca-Cola International based in Atlanta, Georgia. Kumikita sila sa bawat Coke na iniinom mo kasi nanggagaling yan sa syrup. At yung Coca-Cola export, yan ang in charge dyan. Yan. Tanggal siya. She was holding a confidential position as senior financial accountant, and he had access to delicate and sensitive matters. So, loss of trust. is really applicable to her. Yan ang citation. Okay, next case is salesperson sa Toyota. Ito sa mga insurance naman ito ng car. Sometimes when you trust your people and you do not exercise supervision and control, too much trust will also embolden these people to commit deceitful acts and dishonest. So this person na itago lang natin sa tunay niyang pangalan na si Belma de Peralta was dismissed because of falsification. Talo siya dito. She lost this case. Pero merong isang issue panalo siya. Yung namang commission. No? Kasi merong commission eh. So insofar as the money claims is concerned, panalo siya. Pero doon sa termination of employment, talo siya because that is dishonesty. You cannot do that. Okay, itong bouncing check. San Miguel to, Carmelita Santos. I know this girl, this woman. And this woman occupied a very high position. Director of San Miguel Beer Division. Can you imagine, director ka sa San Miguel, that is an officer position. And the problem with this lady, I don't know what happened to her. Check. For instance, pumunta ka sa mga sales office ng San Miguel, there is a lot of cash. Because you know, beer is a very this is a product that is very fast moving. Fast moving ito. No, bida battle yesterday, ngayon iniinom na. So fast moving. So yung mga sari-sari store, yung mga outlet, nagbabayad ng cash. So itong ginagawa niya, lahat ng mga sales office sa Cubao, sa Pasay, sa Pasig, puntahan niya din, mag-issue siya ng post-dated check, kunin niya yung cash. Nag-bounce, na dishonored, drawn against insufficient funds. And these are 150,000 checks. Malalaking amount ang iba. So, na-audit siya, terminate ang services niya. And this is unforgivable because she was a director for finance. No. So, another case is the case of telecommunication distributor specialist, customer sales assistant of a company with direct access to company assets. So, ito, nagbebenta ng cellphone ito eh. And so many complaints from customer about forgery of signatures and many other acts that constitute dishonesty. And so, madalit sabi, tanggal na naman siya dito. Next is Meralco, bill collector. No? So, this one is assigned here in our area in Paranaque, Muntinlupa area. And he has been audited and he was found to manipulate the issuance of receipts para bang ino-overbilling yung mga alam niya may mga kaya na mga residents, ino-overbilling niya, minamanipulate niya yung mga resibo makarating sa opisina na maliit lang ang consumption ng taong ito. Pero actually sa reading, mataas ang consumption, pagkatapos kinukuha niya yung balanse and he was discovered. the tragedy here is he died. This person died. And of course, no, after spending so many years with the company, and his family did not get anything from retirement because everything is forfeited, aside from the fact na nasira pa yung pangalan ng pamilya. Next is moonlighting. What is moonlighting? When you use the company personnel and company resources to do other businesses, in fact, competing with your own employer. This is decided by the Supreme Court, 2018, Justice Tiham. Classmate ito ni Presidente, si Justice Tiham Sanbeda. Retired na ito retired na. So, ito si Joyce, kung nakikinig sa akin ngayon si Joyce, wala akong magagawa kasi this is a public document and decided by the Supreme Court. Okay? Ma'am Crispy, ito yung sinabi ko sa iyo sa UE, there was a faculty member who was dismissed for cause because of plagiarism. And this was decided by your parente, Justice Velasco. This is the father of Speaker Alan Velasco, who was my student in UST. The Speaker of the House now was my student in 1992 or 1993. He was under me in labor law and in other subjects. And the father is the one who decided this case. No? Justice Presbytero our HR manager is with us. No? Dean Wagas, we have more than 63 people now. No,
Yes.
very good attendance. I hope you will come back now only for 2 hours every Monday, and there are many things to learn. Next meeting, be sure to attend because we will discuss gross negligence, gross and habitual negligence. We have finished serious misconduct and insubordination. Now is about fraud and loss of trust. No? Okay. Ito, loss of trust and confidence against this is a multi-purpose cooperative operating the canteen in the BIR, and this was also involving malversation of fund of the cooperative by Grace Aluag, and he was dismissed. And ito again, digital telecommunication. This is about falsifying receipts, no, as a means to malverse company fund. Now we will go to the banks. You know, I will tell you a story which is very sad. There was a guy who worked for Metro Bank all his life. He had only one employer. And he served the bank for 30 years. And he was about to receive a very big amount of retirement pay. But instead of being allowed to retire, the head office of the bank asked him to remain for another 1 year extension. So he was asked, are you going to get your retirement pay and then we will rehire you? or we will just continue your tenure. Doon siya nagkamali. Kasi kung sana na-guided siya, he should have gotten his more than 12 million retirement pay. But because of 15 million retirement benefits, ang sabi niya, hindi ko na lang kunin muna kasi baka tumaas yung basic ko, so lalaki pa yung 15 million eh. But in the meanwhile, within the 1 year of his extension, he was audited and he was discovered to have allowed his relatives and friends to do kiting activity. You know what is kiting activity? Only the finance expert will understand that term kiting. Yung ba mangutang ka din ang maging guarantee mo is a post-dated check. Tapos pag naging due yung post-dated check, i-issuehan mo na naman uli ng another post-dated check. So, parang pinapaikot-ikot mo lang yung post-dated check na wala namang deposit. So ngayon, the bank has suffered because there were checks that were drawn against insufficient fund. And because of this, he lost his 15 million retirement benefits because of friendship, no? Kaya nga minsan ang magpapahamak sa atin yung mga kaibigan natin eh. You just reflect on it na kung sino yung malapit sa iyo, kung sino yung minamahal mo, kung sino yung pinagtiwalaan mo, yun ang magpapahamak sa iyo. Yan ang kasabihan na you always hurt the one you love. Lagi mong nasasaktan kung sino yung malapit sa iyo. At because yun ang pinagtiwalaan mo eh. Kung sino yung pinagtiwalaan mo, yan ang sinabi ni Caesar, ni Julius Caesar, nung siya ay sinaksak ni Brutus sa Senado sa Roman Empire. No? Ganon din ang mangyayari sa mga magkaibigan, nag-aaway dahil sa pera o kapangyarihan. Tatlong P lang yun eh. Pera, power, at saka pag-ibig. Yan lang pag-aawayan. No? And you violate the trust of your friend. Ayan ang nangyari dito kay Mr. C. Mr. C yan eh, Isway sa Davao. Na he retired na zero siya, tapos nasira pa yung kanyang pangalan. He died a very sad and angry man. So, kaya tayo magdadasal para tayo mag-guided ng Panginoon na sabihin mo sa pagdadasal mo, Ma'am Crispy, Lord, I can protect myself against my enemy, but please protect me from my friends, because the friends are the one who knows your secret. The friends are the ones who will betray you. Kasi sila pinagtiwalaan mo.
Amen.
Ito na naman. Yes?
Amen.
Amen. Uy, sino yun? Kuan ba yun? Si Director Jimenez yun? Okay. Sa Pepsi Cola naman, yung nagnanakaw ng MT, parang nangyayari doon sa kaninang kaso, ganun din. Nanakawan mo ng MTs kasi ang MTs, binabayaran niya ng kumpanya. Lahat ng mga empty bottles na magagather ng mga salesmen, may bayad yan pagdalhin mo yan sa planta. So ito, ninakawan niya ng MTs yung mga negosyante. So kuan din yan, that is also a ground. Even if the victim is not the company. Ito, the same to Coca-Cola ito eh. Oh. Parang bumabalik. Pero marami pa ito eh. Nasisira na itong computer ko. Okay. Ito, truck driver. Truck driver, ito Miss Ma'am Valerie. Truck driver for 10 years. Attempting to smuggle out scrap iron worth. Nangyari ito sa Bohol. Sa Bohol tong company, ano ito eh. No? A truck driver was charged with qualified theft. Because when your employee steals from you, it is qualified theft. And in fact, it is non-bailable because of abuse of trust and confidence. And the Supreme Court said that the position of a driver is a position of trust. Therefore, the dismissal was justified since the act of stealing company property was a violation of trust. No? Although maybe he can be absolved by the fiscal or the court, but in the administrative case of stealing, there is sufficient evidence to terminate his services. So even his 10 years of service is not a mitigating circumstance. It is irrelevant to the dismissal. So even if the case before the court for criminal offense is dismissed by the court, it doesn't matter because his acquittal does not mean that he is not guilty of the administrative offense of bringing out company property without permission from the owner with intent to gain. That is pilferage of company property. And it does not require proof beyond reasonable doubt. All that is required is substantial evidence, which we have defined already many times. What is a substantial evidence? It is that degree of proof which a reasonable mind would accept, even if you do not see it with your eyes, but a mind would accept to support a logical conclusion. By process of elimination, even if the evidence is circumstantial, if it is a logical conclusion that he is guilty, then that's enough. Although in criminal court, that is not enough for conviction, but in a labor case, that is enough. The trial court acquitted the accused not because he did not commit the offense, but because of reasonable doubt. So it doesn't matter. It does not affect the administrative case. So we will now go to another case involving a bank, head of Visa Credit Department. You know, this case was mishandled by maybe who mishandled this because the ABP was accused by the bank management of being involved in the fake Visa cards. And at that time, he was in charge. He was the head of the department. But later on, he was transferred to another department. He turned over the responsibility to a new head. And yet, he was the one being charged. Well, I think he was guilty, but management was not able to establish by evidence. So the Supreme Court said that his dismissal was illegal because there was lack of substantial evidence. That is the magic word, substantial evidence. I will just skip. Now, here in BPI, this happens in Dagupan. This is audit of the branch manager. This is a branch manager, senior manager. And there were a lot of anomalies like questionable payments for repainting of the office. No? There was connivance with the supplier and the contractor, and reversal of accrued expenses without official receipts. These are violation of banking rules, which undermine the credibility of Bank of PI, which is a very prestigious bank. Irregular encashment of another bank's check against cash involved beyond banking hours. Can you imagine that? That is an irregular transaction because after the banking hours, they will make a reconciliation of all the transactions and they will close the book for that day. And yet, this manager allowed a banking transaction to happen beyond banking hours. Kaya merong banking hours because that is the cut-off. And then daylight borrowing. Ano yung daylight borrowing? Ganito yan. Daylight borrowing, sabihin ko sa inyo. Pag umaga, yung branch manager, pupunta siya sa cashier, sabi niya, hihiram ako ng 300,000 pesos. Kuha siya sa cashier. Siyempre, cashier, hindi yan maghihindi kasi, sir, basta sir, ibalik mo yan ha, bago mag 3 o'clock sa hapon ha, kasi kailangan magbalansin tayo. Wala akong bahala. Akong manager dito eh. Sunod sila. Then, anong gawin niya sa pera niya? May bata-bata siya, yung driver niya, bodyguard. Punta ka sa palengke, ipa-5-6 mo yung 300,000. Can you imagine? Yung halimbawa, yung 50,000 magiging 60,000 in a matter of hours. Bili ka ng palengke, marami doon. Kaya ang daming nagninegosyo doon ng mga mga pahiram ng pera na 5-6. So, pagkahapon, balik naman niya. Alam mo naman, meron talagang mga whistleblower eh. Meron talagang whistleblower. So, talaga natanggal yung taong ito. Because these are very highly anomalous transaction. And tingnan mo, sa labor order, panalo siya. Pero pagdating sa Supreme Court, talo siya. Labor arbiter, iba ito, PLDT na ito. This is another case, PLDT. PLDT senior lineman usurping the function of the inspector, collecting money from clients, 1,500 per telephone connection. Ang trabaho niya lineman, no? Tapos hindi siya dapat mangulikta. That is not the job of a lineman. And if you are the customer, you are not supposed to transact business with these people because they are just technical people to do the connection. Nanghingi ng pera. Tapos expedite. Tanggal siya. Tanggal after 20 years of service. 20 years of service. Because the Supreme Court said, such misconduct committed by respondent makes him unworthy of the trust demanded by his position. Unworthy of the trust. Malinaw na sinasabi ng Supreme Court. Kanyo ito kasi dito nangyayari ito sa Cebu. This is the bank in Cebu. Metrobank din yata ito eh. Okay. Cebu Bank Operation is the central office for all Visayas operation. So it is coordinating all the banking operation in Visayas. Ito, Metrobank. So these people by the name of itong si Triple A, ang pangalan niya si Triple A. Bakit? Si Antonio A. Abok, no? Kilala ba niyo yan? Si Antonio A. Abok. Ang kasalanan niya marami. Una niyang kasalanan, no? Nagtayo sila ng kooperatiba, credit union, and they are doing business. Credit union, pangpahiram ng pera yan eh. Credit union yan eh. So, they are competing with the bank, their own employer, because the credit union of the employees was doing business inside the bank using banking hours, using banking facilities, and even stealing the customer of the bank. Pag nangutang ka sa bangko, sabihin na wala akong collateral, bubulangan nila sa credit union ka na lang. So, ibig sabihin you are trying to divert the customer of the bank to this credit union. And so, yung mga deposit, placement, loans, yung sa kanilang credit union, they were doing that inside the bank during working hours. And he was the co-signatory with his boss. Alam mo yung boss niya, nag-resign voluntarily. Pero siya, lumaban siya. Talo siya. Natalo siya sa kasong ito. Panalo siya sa labor arbiter, pero talo siya sa NLRC, talo siya Court of Appeals, talo sa Supreme Court. So, isang beses lang siya nanalo. The evidence against the senior manager, Abok, the act of Abok, in helping his boss organize 2 credit unions. Kaya naman lumakas ang loob nito ni Abok dahil yung kanyang manager ang pasimuno eh. Yung manager dapat yun talaga ang dapat unang tanggalin. Pero paano mo tanggalin? Nag-resign eh. Dapat hindi yun tinanggap ng management ang resignation. Your resignation is not accepted because there is a pending case against you. If we find guilt in you after due process, you don't need to resign because we will terminate your services. Yung mga HR iba, tamad. Sabihin na, sir, wag na nating tanggalin. I-resign na lang. O ngayon, pag nag-resign yan, bigyan mo yan ng certificate of employment. Tapos pag later on, papailan ka ng kaso, illegal dismissal, using the certificate of employment that you issue. Dapat pag nag-issue ka ng certificate of employment, you have to state that he resigned while there is a pending case against you. Therefore, this certificate is not a clearance of his accountability because he did not give a chance to management to make a final determination as to his guilt. So he left with a cloud of doubt in his name. Ganon ang mga matatalinong HR. Kasi alam mo, sa talino ng HR napaglalamangan din ng mga empleyado eh. Ma'am, maawa ka sa akin kasi mag-apply pa ako, then I will use certificate of employment. Tapos bigyan mo ng certificate of employment na honorable siya. Para bang transcript ito, ma'am, honorable dismissal. Samantalang later on, he will use that document that you issue against the company, against the university. So, you are providing armament to your enemy. So you have to be careful, no? Hindi naman masama maawa ka, but you have to be aware that you should be loyal to the company. You should think that Ano kayang gagawin niya to certificate of employment? Bakit niya kukunin to? Samantalang at the end, that is, pagkatapos sasabihin mo, maraming kasalanan yan. Pag nag-file ng kaso, you will state that in the position paper. Then why did you issue a clean slate of certificate of employment without making reference to the pending case? No? Precisely, he was about to be found guilty. So as a way out, he resigned. So why do you approve a resignation while the case is pending? Kasi sabihin, graceful exit. Sorry ha, Ma'am Grace ha. Graceful exit. Graceful exit. Meron mga tao who deserves graceful exit. But if you have a pending case, in fairness to you, if you are innocent, let us finish this proceeding so that if you are innocent, then you are proud and say, you know, I was exonerated. But if you are guilty, then you have to face the music. Because you did this voluntarily. My pain and my anguish is when I find some employees who are really deserving of dismissal, and yet when they file cases, they are able to mislead the court that they are deserving to be reinstated. No? That is also injustice. Ito, opening of fictitious account. Tapos he induced a Metrobank client to withdraw her account and transfer it to the credit union. Sasabihin pa niya, dito kaya sa amin kasi mas mataas ang interest namin. Oh, hindi ba yan pagtataksil ni Judas? And that is the highest form of ingratitude, sabi ng Supreme Court. In the language of the Supreme Court, when you commit a dishonest act against your employer, that is the highest form of ingratitude. Yan, credit union checks were allowed to be withdrawn immediately. So mag-issue sila ng credit union check, tapos i-withdraw nila, walang clearing. Ibig sabihin, i-encash nila doon sa teller ng Metrobank. Oh. Wala bang mag-audit? Kaya may auditor eh. No? Alam mo kasi, dapat alam nating hindi natutulog ang Diyos. Hindi natutulog ang Diyos. At kung hindi man kung naidlip man yung Diyos, ay yung konsensya natin. Kaya tayo nilagyan ng konsensya ng Diyos eh. Because that is the internal control system that God has invented and embedded in our personality, our conscience. Because if there's no auditor, if there is no superior, if there is no policeman, if there is no judge, there is the conscience that will haunt you even if you are alone. Yan o, Antonio Abok versus Metrobank. Kita mo. Ito naman sa Robinson. Alam mo, nakakatawa ito eh. 2 weeks lang ito. Napapagalitan ng Supreme Court itong Robinson dito. Bakit? Itong kawawang dalaga, ang ganda pa naman na sales clerk. Cashier din siguro ito kasi nawala yung 20,000 doon sa cash box. And this woman was bodily searched and she was stripped. Can you imagine that? That is inhuman. And that is a violation of the dignity of a woman. Pwede yung kasuhan sexual harassment eh. Pero mo, hubaran mo yung teller kasi hinanap yung 20,000. Saan mo ilalagay yung 20,000? Tapos he was jailed and charged criminally. But, you know, she was exonerated. There is no evidence against her. But she was dismissed by management without due process. No? So the arbiter ordered Robinson to reinstate. Pagdating sa NLRC, panalo ito siya from arbiter, from NLRC to Court of Appeal, Supreme Court. Sino kaya nagnakaw itong 20,000? Bakit? Para bang itong salita, ma'am, na scapegoat at saka yung tinatawag na you are the sacrificial lamb. Ano, bakit pagkasalanan mga animal ang ginagamit? No? Scapegoat at saka sacrificial lamb. Somebody got this money and she was the most vulnerable because she just started 2 weeks pa lang siya. Tapos hinubaran siya. Dinala siya sa presento. Binilanggo siya. Ito, binigyan ng kwanto. Moral damages. Moral damages yan eh. Because of mental anguish and serious anxiety and wounded feelings. So many cases that I have researched on, and my conclusion is always, when it comes to dishonesty, the Supreme Court is unforgiving. Pero itong kaso ng General Milling, I know this case. Because the lawyer for the employee dito was Attorney Songkad, who is a professor of law of the University of San Jose Recoletos. Ito si Attorney Songkad, bata-bata ko yan sa amin sa Ronda. Ako ang naglagay sa kanya sa Pepsi Cola. Tapos itong si Violeta, sister-in-law niya, mayaman tong asawa ni Atty. Songkad eh. Katapos parang hindi pa masyadong believe ang mga pamilya ng wife niya sa kanya. Sabi ko, itong kaso na ito, napanalo ito ni Atty. Songkad sa Supreme Court. For the girl, because this girl was illegally dismissed by General Milling Corporation. Ang problema dito, she was barred from entering the premises of General Milling. And she was denied access to her office computer. She was restricted from punching her daily time record. Na-embarrass siya kasi baka akala ng mga tao ay nagnakaw siya ng kung ano-ano. So, yun ang kuan. The lesson here is, even if the employee is guilty, we have to respect her dignity. We should never commit what Robinson has done and ito General Milling has done. Where this lady was not even allowed to enter the room. You know, this case is not about dishonesty. This is about redundancy, which is the prerogative of the company. But, you know, before redundancy takes effect, there is a 30-day advance notice. And during the 30-day advance notice, the employee maybe not required by management. yan naman, karapatan naman ng management yan. Sabihin na, huwag ka na mag-report because the 30-day period provided by law is to give you a chance to look for another job because you will be receiving money, separation pay. You were not dismissed because you have done something bad against the company. This is an honorable way of ending your career in this company. But you know, hindi yung mag-announce ka ngayon din kinabukasan hindi siya makapasok, he cannot enter her office. Meron siyang computer, may mga personal effects siya, hindi niya makuha. And all the people are whispering around, bakit? Why is he subjected to this? O di nabigyan siya dito ng moral damages. Because, ladies and gentlemen, before we end tonight, I always remind you of Article 19 of the Civil Code. Every employer in the exercise of his prerogative must act with justice, give everyone his due, and observe honesty and good faith. So even if you have the right to terminate the employment, the manner of exercising that right must not be highly offensive to the basic rights and dignity of a person. So it's not just the right, but also the manner of doing the right. So according to Justice Artemio Panganiban in the case of UST Faculty Union versus Betonio, there is a right way to do the right thing at the right time for the right reason, no? For the right reason with the right partner. No? So, ladies and gentlemen, it's almost 8 o'clock. I think I have shared enough data with you tonight. And for our visitors, I appreciate your coming here today. And I hope you will come again every Monday at 6 o'clock up to 8 o'clock. This is for free because I offer this as my gift to my alma mater. Having graduated from this university without paying a single centavo, I am offering my services for the future lawyers from the first University of Cebu, the first, founded in 1919. That's why last year we had our 100 years, and I was the president of the alumni homecoming. Together with Ma'am Crispy Velasco, we were the officers. So I thank you for coming here, and we will take our picture for souvenir purposes. Please open your window. No? Do not
Thank you so much, Attorney
remain
JBJ.
hiding behind
Thank you, USEC.
Thank you so much, Attorney.
Oy, salamat, Ma'am Grace. Sana kita tayo ulit. Attorney Padilagaw
Yes, yes.
and Attorney Ongpad,
USEC, thank you.
Attorney Mistad. Ang daming attorney ngayon, attorney.
Thank you so much.
Dapat kayo magli-lecture.
Attorney. Attorney Dimko is also here, Attorney. Also, Attorney, I see Attorney.
Ay,
Okay.
attorney, yung katabi mo, attorney din yan. Or si Gerald Anderson.
Yes, Attorney. Okay na, Attorney. Thank you so much, everyone.
Okay. Salamat ha.
Ang pink na lang ito.
Thank you,
Thank
everyone.
you.
Thank you,
Did you
Dr.
Attorney, thank you.
Did you
Thank
learn
you,
anything
Yusek.
tonight?
Thank you, USEC. Thank you, Attorney Wagas.
Thank
Ay,
you.
salamat. Balik-balik mo dahil.
Balik-balik mo. Thank you, Panyera Shea. Thank you. Thank you, Panyera Mitch. Thank you, Doc Velasco.
Compañera y compañero.
Yes.
Next Monday.
Thank you so much, Yusek.
Thank you, Attorney Joseph. Thank you.
Thank you. See you next
Salamat.
week. Thank you, Ma'am Michelle.
Thank you,
Kasunod
attorney.
na
Thank you,
puro
attorney.
gross and habitual neglect of duty. Thank you.
Thank you, Yusek. Thank you, Doc Elena. Thank you, Manoy. Thank you, Elgin.
Paano man tigong tog na?
Thank you, everyone. See you next Monday.